Welcome to the AGS seminar, Protecting Your Family's Future. I know some of the participants will be AGS clients, some won't be. We obviously look after income tax, corporation tax for clients, but very often inheritance tax is neglected. So I would like to introduce you to Peter Gate from Meridian. I've worked with Peter for 5 years jointly in trying to protect clients' wealth from inheritance tax. Just a few points to make. The Q&A notes bar at the bottom. If you've got any questions, please just type any questions. We won't be answering them as we go along. We'll answer them at the end of the session. The session in total the webinar will be half an hour with quick Q&As for about 10 or 15 minutes. Without further ado, Peter, welcome. And
thank you. Thanks very much, Steve, and thank you very much for inviting me along to do this. I am a solicitor and a partner at Meridian Private Client. We are a specialist firm of solicitors who specialise in estate planning, so we deal with all of the certainties in life of sort of death and taxes. So I'm not the sort of person you want to speak to if you want cheering up particularly, but I do deal with things which, even 2020 has been a fairly uncertain year and lots of changes for everybody. But, you know, death and taxes is one of those inevitabilities. So what we're going to do today is sort of look at how we can manage your assets and how we can look at protecting those assets so that they can benefit your family long term. So the purpose of this really is thinking about what's known as estate planning. Estate planning is preservation of wealth through tax and estate planning. So sorry, if we can just move on to the next slide. When we talk about estate planning, that really covers a sort of large number of areas. Essentially, it is making sure that should something happen to you, that your assets pass to the people that you want them to. So it passes usually to sort of, you know, spouses and children, and we don't have the problem of large quantities of that wealth passing outside the family, either to the taxman through inheritance tax or also through other potential threats to the wealth. So in terms of money moving outside of the family on divorce, on bankruptcy, or from family members who perhaps are less good with money and might need that money looking after it for them, so they don't spend it on fast cars, gin and tonics, or simply fritter it away. And so what we're going to have a look at in today's session really is why we need to make wills, what sort of things you need to think about when you're making your will, but also wider structuring issues. So looking at your documents other than the wills that need to be dealt with. So thinking about things like pensions and life insurance, touching on whether your family will have to pay some inheritance tax and looking at the rules there, and also thinking about how you can mitigate that inheritance tax, particularly if you own businesses, and also thinking about lasting powers of attorney and what happens if you lose capacity. Moving on to sort of making a simple will, which is the next slide. And now, if I speak to lots of people about this, and lots of people think that if they've made a will, perhaps leaving everything to their spouse and then to their children, that job done, I've done my estate planning and that's a tick in that box. And that's often not the case. And doing this line of work, we see people's affairs when they have passed away, and we see a lot of the problems that supposedly simple wills can result in when somebody dies. So what I want to sort of illustrate here is really that sort of perhaps, you know, making a simple will, going to one of the sort of will writers and producing a very basic will that leaves things to your spouse and children, or even going online and using one of the very cheap or free will writing services that do that, can actually end up making the position worse, or certainly not making the position any better, because these days families' affairs are not straightforward. There are still some sort of traditional families with sort of, you know, a spouse and children, but there's an awful lot of slightly more unusual families with second marriages, children from different relationships, and there's also people have a mix of assets that mean that a simple will often just doesn't do the job. So assets abroad, business assets, or assets that are co-owned with other parties. So one of the big messages here is really a simple will often isn't enough, and that getting valuable getting advice on that is likely to be valuable. What wills often do is, when they're drafted very simply, is that they don't deal with this what we call the asset protection side. So if you simply make a will that leaves everything to your spouse and you die when you're in, say, your 40s or 50s, there could be significant wealth going to your spouse there, but there's a good chance that your spouse will form a relationship with somebody else after your death or remarry, and as a result, significant amounts of wealth can pass to second husbands, wives, new partners, and potentially to their children. So people really need to think about whether they want to put an element of protection in place by using a trust or by ring fencing some of those assets so that they go to your children on the first death, so as to guard against that situation where you leave everything to your spouse and then your spouse runs off with Maria the Spanish waitress or whoever they happen to fall in love with, and they end up with all of the wealth. And that's something that we can very easily cover off in the wills. Perhaps more significant is the fact that if you make a very simple will, or you don't have a will at all, then if you leave assets to your children, then your children will get them on their 18th birthday. Now, those watching this are perhaps were perhaps more mature than me on their 18th birthday, but most 18-year-olds, if they are handed a large sum of cash, often it can do more harm than good. So if you leave it to an 18-year-old, they're going to, you know, they might be spending it on trips to Magaluf or buying fast cars or lots of gin and tonics or whatever the 18-year-olds are doing now. But that may not be how you want them to use the money. And most people, if they're leaving large amounts of wealth to younger people, would rather they spent it on their education, getting a house deposit, and getting themselves established in life. And so there's a real danger if you leave money simply to an 18-year-old, then that gets sort of frittered away, or indeed worse still, it acts as a disincentive to them establishing themselves in life. So they perhaps don't concentrate as much on their studies and don't work quite as hard because they know they've got large amounts of money there. And we see often, with the best of intentions, families leaving money to young people will mean that there can be more harm done in the long term. And trusts can be incorporated in the will so that you can have an element of control there, so that assets don't simply go to the children or grandchildren on their 18th birthday, but rather they are looked after them so that they can be used for house deposits and education and whatever you want. And people often think, oh, trusts in wills, I don't want to establish a trust, it's too complicated and it's going to be very expensive. And generally speaking, you know, trusts do require a little bit more thought and do involve a little bit more work, but it's not a prohibitive amount of additional work. And certainly compared to the risk of all of that money being frittered away by a immature beneficiary, it certainly justifies any additional costs that there might be. So I think one of the key messages here in terms of people thinking about wills is you don't just need to think about where you want that money to go to. You need to think about the asset protection side and at what age you feel people should to get full control of those assets themselves, and also whether you feel comfortable with spouses having full control of those assets so that they can redirect it elsewhere. And if they are things that you're concerned with, then there are very effective solutions that we can put in place for you within your wills. The other thing that people forget is that valuable assets can pass outside of the will. So let me paint a bit of a picture for you here. I dealt with an estate a couple of years ago of a chap who was divorced. He had 2 daughters, was concerned that his daughters didn't get too much money too young. And so he very sensibly put a trust in his will and left everything to his daughters in trust, effectively to pay for their education, house deposits, and then they got it, all the capital sort of to do with what they wanted when they reached the age of 30. Now, he dropped dead of a heart attack, and in his estate, because he got divorced, didn't have a lot of cash, had a valuable house which had a mortgage on it. House was sold. After the mortgage was paid off, we had sort of 200,000 there, which went into trust for his daughters. However, that wasn't the whole story, because what he hadn't done, this man, was think about his other assets that pass outside of the will. Now, his pension assets are often very valuable. People can very easily build up a pension pot of up to £1 million during their working lives, and if they die towards the end of their working lives before they've drawn down on that pension, it can be a very valuable asset indeed. But it doesn't pass in accordance with the will. It passes in accordance with nominations that you might have made when you took out the pension. So this chap had £700,000 in his pension, and when he took that pension out 20 years ago, he simply nominated it to his children. As a result, that £700,000 went to his 2 daughters, so that they had £350,000 each on their 18th birthday, which is exactly what he didn't want to happen. Unfortunately, unfortunately or fortunately, depends which way you look at it, there were more assets. So he was still working, and he had a death in service scheme. Now, death in service is a sort of life insurance that's provided by your employer. And in this case, it paid out 5 times his salary. He was earning best part of 100,000, and therefore there was just shy of £500,000 that paid out on the death in service. Again, death in service payments don't pass in accordance with your will. Again, when he started that job, he would have filled in some forms where he said, oh, if I die, I want my death in service to go to my children. And as a result, the children got that death in service payment, which again was about £500,000. So they got that equally on their 18th birthday. Again, in addition, there was a life insurance policy that he took out that wasn't linked to his work. That was just a standalone life insurance policy. He went to see a financial advisor who said, look, we can insure your life for a couple of £100,000 for this much a month. And he was able to, and he took that policy out. And as a result, but when he took it out, simply filled in the forms and on there, ticked a box to say that he got paid to his children. And as a result, there was another valuable pot of money of £200,000 that went to his daughters on their 18th birthday. So the big point here is that there was a client who thought he'd done everything he needed to do by making a will and setting up a trust to protect things for his daughters. But actually, the majority of his wealth, about £1.5 million, passed outside of the will under the death in service, the life insurance and the pension, and he hadn't thought about those. So a simple will generally doesn't do the job if you have valuable assets like the ones that we've mentioned that pass outside of the will, and you need to think about how you do that, and we'll come on to some of the strategies in a moment. So just moving on to planning and making a will during lockdown, the short answer here is that wills can be made during this lockdown period, and lots of people have chosen to update their wills during the lockdown period because I think, naturally they've been thinking a little bit more about their own mortality, and instructions can be taken over the phone. You still do need to get 2 witnesses to witness your will when you sign it. If you don't have those 2 witnesses, the will be invalid, and the witnesses can't be family members. So it does present challenges. So we've certainly had clients who've been doing sort of, witnessing documents sort of in people's porches at sort of a distance, through windows, through with people in cars. So it is doable, but it does present a challenge at this time. So legislation was also reduced to allow online witnessing of wills, but it's still a last resort, because you still have to sign the will face to face eventually anyway. So the lockdown is not a reason not to get a will done. In fact, it's probably a reason to get a will done more. Moving on to what happens if you don't make a will. So if you think, you know what, why should I have a will? The law will kick in. Well, the law does kick in, and it's something called the intestacy rules, which basically say how you want your assets to be divided. And it's a fairly arbitrary split amongst your family members. And usually it isn't what you want to happen. And on the next slide, you'll see that there's a bit of a flow chart that sort of shows how the intestacy rules kick in and how it works. The intestacy rules rarely work in the way that anyone wants them to on their death. So which is one of the reasons why it's so important to make a will. The other thing to point out here is that if you are not married to your partner, there is no such thing as a sort of common law marriage, and as a result, that partner will simply not inherit anything. So really important to make a will if you fall into those circumstances, because the intestacy rules don't work. Moving on, just to think a little bit about pensions, because many of our clients have got large pensions, which is just on the next slide. You'll see that there's some notes there on pensions, and pensions are great from an inheritance tax point of view because lump sums can pass free of inheritance tax. So it's a way to get assets down a generation completely free of tax. And if you die under the age of 75, it's also free of income tax when the beneficiary takes that asset out of the pension. However, if you simply nominate the pension to your children, then they can take it out at any point. So even if they were very young, they could take that money out. And so there isn't that asset protection there unless you look at nominating your pension assets into a trust. There are some income tax issues around nominating into a trust, which means that the rules here are complicated and you do really need to get some advice on it. But definitely something to think about, and very easy. And we see lots of people who just haven't given a thought to what happens to these valuable lump sums. The next slide covers death in service schemes, which again is something that people don't think about, and are very valuable because again they can pass completely free of inheritance tax. One very neat thing that I do with lots of clients is, rather than the typical nominating that death in service to your spouse, what we often do is nominate it to a trust. So if, say, the death in service was going to pay out £300,000, if you pay that to the spouse, yes, that will be free of tax, but then on the spouse's death, it will be subject to 40% tax when it came down a generation potentially. Whereas if you nominate it into a trust, you can put it into an environment where it isn't part of the spouse's estate for inheritance tax purposes, but they can still benefit from it if they need the money, and it can pass free of inheritance tax down to the children. And the potential inheritance tax saving here is £120,000. So well worth thinking about. Life insurance policies on the next slide are also potentially a very valuable way to get assets down a generation free of inheritance tax. And again, if you write the life insurance policies into a trust and then live for 7 years, effectively that can be a lump sum that can pass completely free of inheritance tax. And again, a £300,000 policy potentially can pass down tax-free, which is a saving of sort of 120,000 if you didn't do anything. Some life insurance companies provide sort of off-the-shelf trust documentation, but this often is inadequate, and therefore we'd really recommend that you look at it alongside the will and get proper advice on that to make sure that it sits properly alongside the will. The next slide I've called sort of bringing it all together, and it's really making the point that you've got these different pots of assets here. So the assets that pass under your will, your pension, death in service, life insurance, you really need to make sure you've got a coherent plan in place that covers all of those assets in place. And that's again one where having professional advice and to bring it all together is really important, because you need to consider both what you want to do with each of those pots and also the different tax treatments of all of the pots in order to make sure that your objectives are met. And that's something where professional advisors like ourselves can really add value. Moving on, just to think about inheritance tax planning. The first thing I'd say here is that we see across our desk at least a couple of times a year people who've gone onto Google, put in inheritance tax planning in, and thought, I'll tell you what, I know what I'm doing here. I will, for example, gift my investment property to my children, and then hope that I live for 7 years, and then it'll be outside of my estate. Now, that is absolutely right, in that if you make a gift and then you live for 7 years, it does fall outside your estate for inheritance tax purposes. But in making that gift, it can trigger capital gains tax. And I had the misfortune earlier this year of breaking it to a family who'd done just that they had a capital gains tax bill of close to £100,000. And we could have avoided that capital gains tax bill by transferring the property into a trust and electing to hold over the gain if they'd come and talk to us first. The rules on inheritance tax are not straightforward, and there are a lot of pitfalls like the capital gains tax problems. If you've got business assets, farming assets, you wanting to make provision for charities, all of those things are not straightforward, and it's well worth having a conversation with us, because there are some very neat ways in which we can mitigate your exposure to inheritance tax. So the next question really on the next slide is will my family have to pay inheritance tax? Now, the short answer there is that more and more families are having to pay inheritance tax. The statistics that the government put out showed that never before have more estates paid inheritance tax, and that number keeps rising. The reason for that is that the nil rate band, so the tax-free allowance for inheritance tax, has been frozen at 325,000 for since now 2007, and obviously house prices have gone up significantly since 2007. So we're seeing more and more people dragged into the inheritance tax net. Married couples have the ability to transfer the nil rate band, so this tax-free amount of 325,000 can be transferred between them. So if it's not used on the first death, it can be used on the second death. So effectively, a spouse has a married couple, sorry, have 650,000 tax-free, which they can leave to their children, and then anything on top of that is 40%. And a 40% tax bill on an estate, where even some fairly normal families with valuable houses can find themselves writing checks for hundreds of thousands of pounds to the taxman. So it's well worth getting some advice and seeing if there's anything you can do to mitigate that tax bill. One thing that was introduced by the David Cameron when he was Prime Minister, one of the last things he did was this residence nil rate band, which you may have heard of. Now, the headline on that was £1 million tax-free for a married couple. And you'll see on the next slide that the residence nil rate band isn't quite as good as that headline suggests. So if you are a married couple and you own a house and you leave that house that you live in to your children or grandchildren, then you can claim an additional inheritance tax allowance to increase from the 650,000 up to £1 million. But you've got to be a married couple, you've got to own a house, and you've got to be leaving it to your children. So if you don't qualify for any of those, then you don't get that additional allowance. And also there's a very nasty trap there where you have to be very careful if you downsize, so that if you move from a larger house to a small bungalow or something like that, that you do it in the right way so as to preserve that allowance. Another very nasty trap is the fact that if your estate is worth more than £2 million, then you start to lose that residence nil rate band, and it peters out and effectively it goes down for every pound over £2 million. So if you're worth sort of north of £2.3 million, then you simply don't have that allowance. So what we've been doing with a number of clients is looking at how we can get their estate under that £2 million threshold in order to get to a position where they can claim that residence nil rate band and save some inheritance tax. The rules here aren't straightforward, and what we want to do is you need to get advice on it. You'll see on the next slide, I've set out a couple of issues there with the nil rate band and some of the wins that you can make. And a good result is that you've got £1 million tax free for a married couple. And if we can protect that for you, then you know we can then look at anything that we can do to mitigate tax on the assets over £1 million. So back to the next slide is again that question as to will my family have to pay inheritance tax? Inheritance tax is judged at the date of death, so quite possibly is the answer there. More and more families are having to pay it, and therefore good to get advice on it. The next point is business property relief, and this is really the rules for business owners that own for inheritance tax. Now, you'll see on the next slide there's the rules that are set out there. Effectively mean that if you own a trading business, then you can get 100% inheritance tax relief on that trading business if you've owned it for 2 years and it continues to be trading to the date of your death. The rules here aren't straightforward, and if you have issues like investment properties or stocks and shares within the business, or you're holding too much cash, then you can easily lose that relief. And what you don't want to do is make a will that leaves your business assets to your spouse so that you lose that relief. So if you own business assets, the structure of your will is really important, and it presents opportunities to get assets down a generation really tax efficiently. So a valuable relief, and one where you want to get advice on it. So moving on, if I just move forward a couple of slides, we'll move on to, as we're running out of time, just to think about lasting powers of attorney. This is the situation where you are still alive, but you no longer have capacity to manage your affairs yourself. And this can happen typically when people get older, because they've had dementia, a stroke, something like that. But also, you know, you fall off your bike and you've got brain damage, or you end up in a coma because you've had COVID. So if you don't have a lasting power of attorney in place, no one can manage your assets for you. And someone would have to apply to the court for permission to look after your assets, which is expensive and time consuming, and something that we really want to avoid. So particularly, and can cause real problems because people simply can't access the cash. So get a lasting power of attorney in place, and that enables your trusted family members or friends or advisors or whoever you feel you want to help manage your affairs in that circumstance to manage your affairs within a matter of days rather than months, as would be the case if you didn't have one in place. So definitely worth having one in place. I've just done a slide next just outlining the probate process. Now the probate process isn't straightforward, and we could do a whole session on probate and what needs to be done when somebody dies. More and more estates are subject to inheritance tax, and there are penalties if you don't do the inheritance tax reporting properly. And whilst it is possible to do probate applications online yourself, you can do inheritance tax returns online yourself, I see week in and week out people coming to us when the taxman has sent them the letter asking for more tax or trying to charge penalties because they've not done things quite right. So I would say often it can be better to get some advice early on so as to maximise the inheritance tax reliefs that you might be able to claim. So just to conclude, really the purpose of this session was just to illustrate that actually having a simple will often isn't enough for you because it doesn't consider the inheritance tax position, and it doesn't consider those assets that might not pass in accordance with the will. If you've got assets, if you're a married couple and you've got assets over £1 million, then inheritance tax planning is going to be really important for you. If you're and the rules aren't straightforward, particularly for a business owner, and we can help you with AGS to get the advice that you need. So even sometimes the most simple set of circumstances can lead to some complicated issues, and you know, we're always AGS is always happy to chat through these issues with you and see if we can help. So I'll hand back to Steve there. I'm sorry that's a bit of a whistle-stop tour through what's quite a complicated area, but hopefully it gives you a flavour for some of the issues, some of the traps, and some of the things that you need to think about.
Thank you, Pete. Obviously, there's one question that's come in, Pete. If you can see that, can you get business property relief on inheritance tax if you're a sole trader, or do I have to be a limited company?
The short answer there is assets held by a sole trader can qualify for business property relief as long as they are definitely used within the company, and they're used within the business and the trade. What's more important is that you are actually a trading business, so you are providing a service that's generating money for you, and it's a genuine business, rather than whether it is in a company, a partnership, or as a sole trader. Often the issues with sole traders come when you have working out exactly what how the business should be managed after your death, because as a sole trader, effectively the business is frozen until your executors get the grant of probate and can step in and manage that business and deal with the winding down of it. So it's even more important for a sole trader to get advice and to make sure that they get a grant of probate speedily.
Yeah. Thank you, Pete. There's a couple more. If you can just read through those, Pete.
Yeah. So second question is asking whether it would be beneficial to try and reduce a person's assets down to under the £2 million bracket to qualify for the residence nil rate band. And the short answer to that is yes, it is. Because if, for example, your assets are worth 2.4 million, then you will only have £650,000 tax-free on death, and it'll be 40% inheritance tax on top of that. But if, for example, you made gifts to family members or to a trust that you'd set up for your family, in order of say £400,000, and you got the assets down to under £2 million, rather than it just being £650,000 tax-free, it goes up to £1 million. So that's something that we are looking at for married couples quite regularly. The really important point to think about that is on the first death, because the £2 million is tested on the second death for a married couple. So often on the first death, we're thinking about diverting some assets to other family members to get it under that £2 million threshold, as long as the surviving spouse is comfortable with this and can afford it.
Yeah.
The third question that's come through is just about the online witnessing process for wills that was introduced recently, and whether we think that there's going to be potential for wills to be contested on the grounds of invalid execution due to the sort of the online witnessing process. And I think the short answer to that is yes, because if you can show that a will is invalid, then some potential beneficiaries might be better off. So if, for example, you're a child, under the intestacy rules, you might get your share outright on your 18th birthday if you can show that the will was executed invalidly. So it may well be that that because this is a sort of new area of the law, this online witnessing, it's likely to be one where you'd have to tread really carefully and see before you actually, because there is a real risk of challenge, particularly if there's likely to be a disgruntled beneficiary.
Yeah.
There we go. And some more questions there. So the next question is who can be my trustees if I set up a trust in my will? Can they be the beneficiaries? So if you're setting up a trust in your will, the trustees can be whoever you whoever you want them to be. Really, the important thing is someone that you trust to follow your wishes. Absolutely no problem with it being the beneficiaries as well, but you've got to work out who's the right person in the circumstances. So if the reason for the trust in the will is to stop your alcoholic child from spending all of that money on alcohol, probably not a good plan to have them as a trustee, because they will not necessarily follow your wishes. But if, for example, you want to set up a trust in your will so that your grandchildren's school fees can be paid, it might be sensible having their parents as the trustees, as they will be managing it. So that is definitely the short answer there is choice of trustees is really important, and it's different in every circumstance. So get advice from someone who's dealt with that before, and to work out who's the best person to have there. The next question is about deeds of variation. So a deed of variation is a document that you can do after somebody has died to vary the terms of the will. And the question here is about business property relief. So that's the fact that business assets can pass tax-free on death. And the question there is, can you do a deed of variation to obtain business property relief? And the short answer there is yes, you can. So if, for example, you hadn't done any planning during your lifetime, you could still potentially use a deed of variation to ensure that business property relief can be claimed on your business assets. So you typically do that if you were leaving assets to a spouse, and then which would be tax-free anyway. So what you might then do is vary that so as to leave the business assets to the children, so that it can pass tax-free down to the children. So yes, that can be a sensible thing to do. There is a time frame for claiming it. It's got to be done within 2 years of the date of death. And the other really important point here is I wouldn't rely on the fact you can do a deed of variation, because deeds of variation require all the beneficiaries to agree. So if, for example, you said, oh, I'll just do a simple will leaving everything to my spouse, and then she or he can do a deed of variation at that time, if your spouse is incapacitated and has lost capacity, then they wouldn't be able to sign a deed of variation. So it's better to get the right will in place to start with, rather than relying on the deed of variation. And then I think the last question that we've got at the moment is a really good one, actually, is the question of how often should you review your will? And I would say to clients, minimum, you should look at it every 5 years, but you should also look at it if there are any changes in your circumstances, or the circumstances of your family. So if there's any big changes in life, if your wealth increases or decreases, if your children's circumstances change, then you should look at your will. If you get married, marriage revokes your will, so that's a really obvious time to look again at the will and see if any changes need to be done. But generally speaking, having a will in place is only worthwhile if you keep it up to date.
Thank you, Peter. Thank you. That's great. I think you can also emphasise the fact that utilising your pensions are key as well. Because that £2 million doesn't include your pension fund, does it, Peter? So, yeah. So if you can manage, your allowance, lifetime allowance on pensions, it is worthwhile looking at trying to utilise that. If your wife and your husband have £1 million each, circa £1 million in personal assets, that's £3 million that you're protected from inheritance tax. So I think our job at AGS is to work with people like Peter at Meridian and join those dots up for you. Very much do a project management work, working on personal allowance bans, corporate tax mitigation, and also making sure we manage your inheritance tax properly. So we like to think we work with these skilled professionals and with the epicentre for you. Thank you very much. I mean, the video will be on a podcast on our website, so you've got a chance to review it. If you want to come and approach me, then by all means give me a call on 01384 217 224. That's my direct line, and more than happy to talk to you about any help and support we can give you in any of those areas. So thank you, Peter, and
Thank you.
and we'll see you all soon. Thank you. Thanks for attending. Bye now.